The employer's rights. First is the employment at will. The employer can terminate the employment relationship with an employee at any time for any reason. Common limitations on the at-will employment relationship are found in labor agreements and employment contracts. Those negotiated agreements will typically impose terms and conditions for terminating an employee. Those contract provisions supersede the at-will relationship and limit the employer's rights to freely terminate the employees. Or in other words, at-will employment is an agreement where the employer is free to terminate an employee at any time for any reason. Exemptions apply. So dito, hindi na kailangang i-disclose ng employer kung ano yung pinagmulan o rason kung bakit niya tinanggal sa trabaho yung employee. However, at-will employment ay nagwo-work din sa employee. Ang employee ay maaaring umalis ng trabaho anytime without giving their employer notice or reason kung bakit sila aalis. So, in general, at-will employment allows an employer and employee to end their relationship at any time and without an explanation. Hindi ito kagaya ng relasyon ng magjowa na kahit na anytime pwedeng tapusin yung relasyon. Kasi ito, kailangan masigurado ng employer na matatapos yung relationship nila ng legal. So next is establish company policies and procedures for workplace performance and behavior. Employers have the right to establish policies and procedures governing such matters as employee ethics, leave policies, pay for performance, and behavior when interacting with customers or the public. Employer policies can include social media usage during work hours and after hours. Employers can also establish dress and grooming standards. Bakit nga ba kailangan mag-establish ang isang company ng dress standards? It is also for safety reasons. Para mabilis silang makilala ng customers, to maintain the professionalism in the workplace, to project a specific brand image or any other business purpose. Having these policies and procedures in writing accessible by all employees helps show they are applied fairly and consistently to all employees and will help an employer defend against an employee claiming unfair or discriminatory treatment. Require mandatory overtime. Nothing prevents employers from requiring their employees to work overtime. However, if an employee works overtime, employers must pay them consistent with applicable federal and state law. So, syempre sa isang business entity o sa trabaho, nagkakaroon talaga ng pagkakataon na nag-overtime ang mga employees. In certain circumstances, sa isang trabaho, maaaring pilitin mag-overtime sa gusto o sa hindi ng isang employee. Maaaring sa work itself or nagkakaroon ng emergencies like typhoon or also to take advantage of the good weather. For example, is yung mga construction worker. So, di ba, hindi naman pwedeng magsamento ng umuulan. Pero kung good weather naman, pwede naman pilitin ng mga employer yung mga employee na mag-overtime. Pero syempre, dapat may overtime pay na binibigay ang employer sa employee kasi karapatan ito ng isang empleyado. Monitor employees' use of office equipments. Employees have very limited rights to personal privacy in the workplace, specifically when the office space and equipment are provided to the employee by the employer. This means employers have the right to monitor employees' use of it. So, mapapansin naman natin na sa isang opisina, for example, is a school faculty, wherein by cubicle lang ang pinaka-opisina ng isang teacher. And that faculty room and the cubicle ay provided ng school. So, in this case, the employer can monitor its employees. Employers can also restrict access to social media and other non-work-related sites. Employers can also search for file cabinets, desks, and offices being used by the employee in the workplace. But before implementing any monitoring activities, employers should know this is a sensitive area of law. Become familiar with the applicable state laws and what limitations, if any, the laws impose on employers' rights.
Monitor employee use of social media in violation of company policy. To ensure that employees comply with the company policy, employers can monitor employees' public posting. If a member can finds a posting that violated the company policy, the employer can take care action. Under the employment at with doctrine, employers can discipline or terminate employees for posting that violate the employer's policies about the social media post. So, sa monitoring, yun yung pwedeng matanggal ang isang empleyado kapag nag-post sa social media. Halimbawa, nag-post si empleyado na ng about dun sa kumpanya, dun sa ikasisira ng kumpanya. So, maaari siyang tanggalan ng trabaho. Next, consult an experienced labor and employment attorney at KPPB law. As employer, you need to understand the rights affordable to employers in the workplace under applicable federal and the state law. In the age of the 24 hours access to the internet and social media platform, the workplace is no longer confined to a specific geography location, such as the limit of employers' rights and significant harm to your company goodwill can occur very quickly. So, yun yung connection between employee and company. Termination of employer-employee relation. Unlike the United States of America, which has an will employment doctrine, employers in the Philippines can also determine their relationship with an employee if it just or authorized cost as defined under the law has been established after undergoing due process. So, natatanggalan ng isang empleyado kung gumawa siya ng hindi maganda kahit sa ang company. Types of employment termination. So, we have the two types of employment termination here in the Philippines, the termination by employer and the voluntary resignation. So, sa termination by employer, yun yung tinanggal mismo ng employer mo, tinanggal ka mismo ng kumpanya. Tapos yung voluntary, binigyan ka pa ng chance para maganda yung record mo, para yung parang ikaw mismo nag-volunteer ka na mag-resign sa trabaho na yon.
Termination by employer. According to Article 282 of the Labor Code, an employer can terminate an employee for just causes, which could be any of the following: serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. Sabi dito, maling pag-uugali daw ng isang employee ang hindi pagsunod sa mga patakaran ng trabaho. Next, gross and habitual neglect by the employee of his duties. Dito naman, sinasabi na kung ikaw ay isang employee, huwag mong papabayaan ang duties mo bilang isang empleyado. Fraud or willful breach by the employee of the trust reposed in him by his employer or duty authorized representative. Dito sinasaad ang mga paglabag ng empleyado ng pagtiwala na itinuturo sa kanya ng kanyang pinagtatrabahuhan. Commission of the crime or offense by the employee against the person of his employer or any immediate member of his family or his duty authorized representatives. Dito naman, sinasabi, komisyon ng isang krimen o pagkakasala ng empleyado sa kanyang pinagtatrabahuhan. Voluntary resignation. This type of termination is threatened by the provision of Act 285 of the Labor Code, which recognizes two kinds of termination an employee can initiate without just cause and with just cause. If the resignation is without just cause, the employee must give 1 month advance written notice for resignation, commonly referred to as resignation letter, to the employer to enable them to look for a replacement and prevent work disruption. Ang sabi naman dito, ang ganitong uri daw ng pag-resign ay pinagtibay ng Provision Act 285 ng Labor Code, na makilala ang dalawang uri ng pagwawakas na maaaring simula ng isang empleyado ng walang makatarungang dahilan at may makatarungang dahilan. Ang empleyado ay dapat magbigay ng isang buwan na advance na nakasulat na paunawa para sa pagbibitiw sa tungkulin. Karaniwang tinutukoy bilang sulat ng pagbibitiw sa employer na pagganahin silang kumuha ng kapalit at maiwasan ang pagkagambala ng trabaho. If the resignation is with just cause, however, the employee need not serve as a resignation notice. Act 285 indicates the just causes for resignation as follows. O yon, ito na yon. Serious insult to the honor and person of the employee. Then, inhuman and unbearable treatment accorded the employee by the employer of his representative. O, so yun din. Crime committed against the person of the employee or any immediate members of the employee's family and other similar causes. Due process in termination of employment. The due process is different for both authorized and just causes. Just cause involves a 2-notice rule while authorized cause requires a 30 days notice. If due process is not accorded to the employee before termination of the employment, of the termination itself is declared illegal, the employee is entitled to receive reinstatement and full back wage Act 279 Labor Code. If reinstatement is no longer possible where the dismissal was unjust, separation by may be granted.
Dismissal based on just causes involve the 2-notice rule. First is a written notice, commonly referred to as a notice to explain specifying the grounds of termination and giving the employee ample opportunity to explain their side. Dito naman, example lang dito yung nakagawa ka ng labag sa rules ng isang company and then papadalang ka ng boss mo ng written notice. Syempre, kailangan mo mag-report and then kahit may possibility na mawalan ka ng trabaho dahil dun sa nagawa mo, kailangan ka pa din nila bigyan ng opportunity na i-explain yung side mo sa kanila. And next is a hearing of conference to allow employee to respond the charges, present evidence, or rebut the evidence presented against them. Dito naman, halos parehas lang din siya dun sa panguna. Kasi need mo din dito mag-explain ng side mo para maipaliwanag mo sa kanila kung bakit mo nagawa yung paglabag o ba't mo nasuwa yung rules ng company nila. And then, last is a notice of decision indicating the justification for termination as well the corresponding sanctions after due consideration of all evidence. Dito naman yung papaliwanag ng employer sa kanyang employee yung kakaharapin niyang sanctions o dahil sa ginawa niyang paglabag sa rules ng company nila. Due process for authorized causes. Dismissals based on authorized causes involve the following: submissions of a written notice of dismissal to the employee specifying the grounds for dismissal at least 30 days before the date of termination. Dito naman, malapit na matapos yung kontrata mo and then nakagawa ka ng labag sa rules ng company. And then, may possibility na matanggal ka agad kahit hindi pa end yung contract mo. Kasi, yun yung nakalagay sa kasulatan ng company nila na pag nakagawa ka ng labag sa rules nila and then sumobra ka, pwede kang matanggal kahit hindi pa end yung contract mo. And next is a copy of notice which shall be provided to regional office of the Department of Labor and Employment, which is DOLE, where the employer is located. Anti-Sexual Harassment Act of 1995. An act declaring sexual harassment unlawful in the employment, education, or training environment and for other purposes. Dito naman, ito yung sapilitang paghiling o pag-utos ng sexual na pabor sa'yo ng isang employer o sino mang may kapangyarihan na mag-utos sa'yo sa trabaho man o sa paaralan. And next is Declaration of Policy. The state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect of human rights, and uphold the dignity of workers, employees, applicants for employment, students, or those undergoing training, instruction, or education. Dito naman yung pagpapahalaga sa dignidad ng bawat individual at buong paggalang sa karapatang pantao. At ito rin yung pagbibigay ng dignidad sa mga trabahador, manggagawa, empleyado, at mga aplikante para sa kanilang mga trabaho.
Section 3. Work education or training-related sexual harassment defined in a work-related or employment environment. Sexual harassment is committed when the sexual favor is made as a condition in hiring or in employment, re-employment, or continuous employment or said individual. So, ito daw ay nahingi ng kapalit ang employer ng sexual, nahingi ng, kunyari ay, makikipag-sex siya para ma-hire siya sa kumpanya. Or mapataas ang ranggo o mapatagal pa ang pagtitrabaho niya sa kumpanya. The above act when appeared the employee's right or privilege under existing labor law. The above act when result in a intimidating, hostile, or offense environment for the employee. In education or training environment, sexual harassment is committed first against one who under care, custody, or supervision of offender. Second, against whose education, training, apprenticeship, or tutorship in trust to the offender. Ito daw yung mga baguhan lang at ang mga nangyayari yung sexual harassment is yung mga nakataas sa kanila. When the sexual favor is made on condition to giving a passing grade or granting honor or scholarship or payment or stipend allowance or another benefits, privilege, or consideration. When the sexual advance result in a intimidating, hostility, or offensive environment or for the student, trainee, or parents. Ito daw yung mga nangyayari pag yung kapalit ay yung mga passing grade, honors, or saka yung mga mga benefits na pwede ibigay Section 4, duty of the employer or head of office in work-related education or training environment. Formulated appropriate result and regulation and consultation with a joining approval of the employer or student trainee. Create a committed or secure room and investigation or case sexual harassment.
Section 5. The liability of the employer, head of office, educational or training institution. The employer or head of office, educational or training institution shall be solidarily liable for damages arising from the acts of sexual harassment committed in the employment, education, or training environment if the employer or head of office, educational or training institution is informed of such acts by the offended party and no immediate action is taken. Section 6. Independent action for damages. Nothing in this act shall preclude the victim of work, education, or training-related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. In this Section 6, sinasabi na walang makakapigil sa biktima ng sexual harassment na mag-establish ng independent action. Yung independent action is the amount of decision-making, initiative, and responsive action dun sa nangyari sa kanya, or a relief request for the injury or damage she have been suffered during the factual situation. Dito naman sa Section 7, nakasaad yung mga penalties dun sa mga taong nag-commit ng sexual harassment. First is na pwede silang makulong ng not less than 1 month or not more than 6 months. Or pwede silang magbayad ng 10,000 pesos or more than 20,000 pesos. Or both the fine and imprisonment. Depende sa paghuhusga ng korte. Any action arising from the violation of the provisions of this Act shall prescribe in 3 years. Section 8, Separability Clause. If any portion or provisions of this Act is declared void or unconstitutional, the remaining portions or provisions hereof shall not be affected by such declaration. Or kung anumang bahagi o probisyon ng batas na ito ay idinideklarang walang bisa o labag sa konstitusyon, ang natitirang mga bahagi o probisyon dito ay hindi maapektuhan ng magiging deklarasyon or ng desisyon. Section 9, Repealing Clause. All laws, decrees, orders, rules, and regulations, other issuances, or parts na hindi naaayon sa mga probisyon ng batas na ito ay inaalis na o binabago ng naaayon sa tama. Section 10, Effectivity Clause. This Act shall take effect 15 days after its complete publication in at least 2 national newspapers of general circulation. O ang mga karapatan ng kababaihan at lahat ng mga probisyon ng batas na ito ay dapat na magkabisa kaagad within 15 days, pagkatapos ng kumpletong paglalathala nito sa hindi bababa sa 2 pambansang pahayagan. Liability of the employer, head of office, educational or training institutions. Sa huling topic na ito, the liability of the employer, head of office, educational or training institution, ang ibig sabihin lamang nito ay sinasabi dito na kung sakali na hindi magagawan agad ng aksyon kapag nagkaroon ng harassment sa isang institusyon o sa opisina o sa paaralan, ay ang mananagot ay ang employer or head of office, educational or training institution sa magiging pinsala nito sa trabaho.